All right, good morning, everyone. It is Wednesday, December 21st, almost the holidays. Hope you guys are all preparing and are getting excited. Couple of forum-based notes just before we begin. As always, we'll start at 10:05, so I get 3 minutes to make my notes. One, we're about probably 10 or 15 members away from 11,000 members. So I'm going to ask every one of you, if you know professionals who are looking to be part of our forum, remember they have to be professionals. Please invite them. It would be a pleasure to have them as part of our group. The more the merrier. The more people there are that are contributing and are active, the better off we all are. We benefit from everyone's active participation. So please do invite your friends. And let's see if we can crack that $11,000 or 11,000 person metric. Number two, as with all of our talks, and I say this every time, our forum is private, our videos are public. Anything that is said here will be put out on any number of forums and will be watched over successive years. So please be aware of that, and you've been duly advised. Last, just as an aside and before we begin, it's worthwhile mentioning that one of our own, Naveed Data, who many of you may know, was shot and unfortunately succumbed to his injuries this week in the condo shooting that took place. Naveed actually had made some comments actually about this very event which he was going to attend and was an active member of our forum. And before we begin, especially for those who had the pleasure of knowing him, I would note that we've lost one of our own, and we should think. Apparently, from those who know him, he was a wonderful individual, a joyous individual, and someone who would want us to remember him that way. I would encourage us all to do so. And with that somber message, we'll turn our attention to the order of the day. So we're back here with Matthew Gibson. Matthew has been good enough to present to us in the past. Matt is my go-to guy when I have power of sale questions. As you can see, he's a young guy, which is, and I mean that in a great way, because young lawyers who know what they're doing and have the energy to pursue leads are really the best of us. And Matt is exactly that. He's replete with knowledge, and his practice focuses and is centered around power of sale activities. We are entering into a new world. Those of you who track power of sale activities on MLS, which by the way is trackable simply by searching the term power of sale, will note that they are increasing fast and furious, and not only in lower or lesser brackets, they are increasing in upper income brackets as well. $6 million, $7 million, $8 million power of sales. I've seen them routinely in my office in the past month. So we are really entering into a brave new world. When power of sale is engineered by a bank or a lender, they usually use their own Schedule B, which causes great fear for a lot of agents and for their clients. And Matt is here to kind of take us through, demystify the process. And of course, I would significantly encourage everyone who has questions with regards to their own power of sales to start using Matt as a resource, as I do and as others do who know his acumen and who know his knowledge and breadth of knowledge in the subject. So without further ado, Matt, over to you. You got your 55 minutes, and however you choose to use it, we're very grateful for your time.
Great. Well, there's just no way to live up to that intro, but I'll do my best. So yeah, as Mark mentioned, my practice focuses. It's sort of a two-pronged approach. So we do your typical transactional real estate, residential, commercial, industrial, buy, sell, refinance. But the other and what's an increasing element of my practice now is the power sale process, acting for lenders. Be it institutional lenders, private lenders, mortgage investment corporations, that sort of thing. And just anecdotally, I can confirm that this is certainly a trend on the rise right now. In the past year, I would typically have 2 or 3 maybe power sale actions cross my desk in a month. And I've got about 24, 25 currently active that have all sort of come in the last 3 months. So a couple things that I think are relating to that, just to sort of try and understand the trend a bit more is number one, obviously people are having issues with making their mortgage payments as interest rates are going up, especially with bank mortgages, variable rates. We've all seen the news stories about trigger rates and payments. I'm feeling that same squeeze myself, as I'm sure many of you are. But the other element, I think this is the bigger element, is just the disappearing equity, or the perception of disappearing equity. A lot of lenders in the past, if they had a good borrower and that borrower, falls behind 3, 4, 5, 8, 10 months maybe, but they're seeing property values go up 20, 30% a year, they're not really concerned about their equity. They're willing to let that slide. A lot of people, when COVID was sort of at its peak, were doing, mortgage forgiveness, or just putting it off, or saying, okay, these 4 months that you missed, we're just going to add that to the principal on payout in 2 years, because we know the property is going to keep going up in value forever, because that's how real estate works. And now we're seeing, well, that $600,000 mortgage that you had on an $800,000 house is now on a $700,000 house. You got a little less room there. You're a little less confident. As those payments stop coming in, you're wanting to move quicker. So that's what we're seeing. And to Mark's other point, we are seeing it on all sort of sizes of mortgages. I have everything from a $40,000 mortgage that's in default to a $1.7 million mortgage that's in default. A lot of people living beyond their means, and or running into issues with losing employment, or having trouble paying their first mortgage because that rate has gone up, and so now the second mortgage is suffering. So there's a whole a range of factors that's contributing to this. But what this means for you, for the realtors in the group, is that you're going to be seeing more of these properties coming up for sale, and needing to understand how to approach that, how to protect your client as the buyer. Some of you may get tapped to attack for sellers, and I'm happy to give some information about that to individuals working on that side. But for the purposes of this presentation, we wanted to focus on acting for the buyer, because when you're acting for the seller, the lawyer is already involved right from the start, so you kind of have that guidance. But when you're acting for the seller, you may not have a lawyer involved right up front, and so you need to understand what you're getting what your client is getting into by going into this process. So I am going to share. I do have a document. Last time I did a PowerPoint presentation. This time I got lazy and just did a PDF, but I will share the PDF afterwards for everybody to have. But I'm just going to put it on my share screen right now, and we'll sort of walk through that. So just to give a quick background or refresher on what power of sale is, power of sale is different from foreclosure. And we often get people that are sort of confusing the two, say, oh, I want to foreclose on this mortgage. A power of sale is what's known as an extrajudicial remedy. So technically speaking, for power of sale, you do not need to involve the courts. You do not need to involve the judicial system. Under the power of sale provisions, either in your mortgage or in the Mortgages Act, a mortgagee, so mortgagee is the lender, mortgagor being the borrower. A mortgagee has the right, when a mortgage goes into default, be it through non-payment, through lapsing of insurance, through lapsing in property taxes, or if there are other specific provisions in the mortgage that lay out what a default is. When a mortgage goes into default, a mortgagee has the right to remedy that default by selling the property, collecting what is owed under the mortgage. Generally speaking, in practical terms, a judicial process or a court process does happen, because taking possession of the property, where the property is occupied by the mortgagor, the owner, or by tenants, or just anybody, basically, generally you are going to need a writ of possession. You're going to have to effect an eviction. But from a purely technical standpoint, and I actually just dealt with this yesterday, you don't need a court order if you're able to take quiet possession of the property. So yesterday, I actually at 11 o'clock met with a locksmith at 2 properties in Hamilton with our notice of power of sale, and the properties had been abandoned because the owner had actually declared bankruptcy. Trustee in bankruptcy said, sure, we're not going to interfere with your mortgage, with your power of sale process. And we were able to show up, change the locks, and take possession without needing an eviction order, without needing a writ. And we're going to be able to sell the properties in January. But the important thing, one of the important things to note is that when the mortgagee takes possession of the property after the process, however they get there, they become what's known as the mortgagee in possession. They are not the owner of the property. They do not ever become the legal owner of the property. That is a foreclosure action, much more rare in Ontario. Power of sale means we don't ever have to become the owner of the property. We can sell the property as the mortgagee in possession. And then what happens with the money is the mortgages get paid off in the order they're registered. If there's other secured or registered securities on the property, those will get paid out. Any money left over then goes to the mortgagor, the owner. And we'll talk a bit more about that in a second. But what that means for you is that you are buying the property from the bank or from the mortgagee, but the mortgagee is not the owner. And the reason that's important is sort of everything else we're going to talk about. As the mortgagee is not the owner, they can't make most of the standard reps and warranties that an owner can. Just because the bank is in possession doesn't mean they have any actual knowledge about the history of the property, about the any damage to the property, the ownership of chattels and fixtures, all these things that we're going to talk about. And that's the reason why, is they're just in possession, but they don't own the property. Another sort of important element to know when you're maybe looking at buying a property under power of sale for a client or for yourself is that the mortgagee has a duty to obtain fair market value. So a lot of people think, oh, the bank's taken the house, they're going to sell it for a song and I'll be able to get a great deal on it. And that's not really the reality. There's a significant case law and legislation that dictates that the mortgagee has to give sort of best efforts to get fair market value at the time they choose to sell the property. So what does that look like practically speaking? 1 or 2 appraisals. Property is going to be listed publicly. It's going to be sold at an arm's length. There's a number of lawyers that have gotten in trouble for selling mortgage properties not at arm's length to family members, friends, pocket deals, and you can get in a lot of trouble for that. So we avoid that at all costs. And so just a quote here from the case that I cite. You'll see there's some footnotes here. In addition to the duty of acting in good faith, the mortgagee is under a duty to take reasonable care to obtain whatever is the true market value of the mortgage property at the moment he chooses to sell it. And the reason for this, or the possible sort of result of not doing this, is what's known as an improvident sale. And so under an improvident sale, the mortgagor, the owner of the property, or a subsequent mortgagee. So if I'm the first mortgage holder and there's another person behind me, and I sell the property for a huge discount because I just want to get what I'm owed, I don't care about anybody else, that second mortgage holder can sue me saying, you undersold the property. I would have gotten, if you had sold it for 100K more, that, which is what it was worth, I would have gotten that money. And so, but the fact that you undersold it or sold it under value means that I got screwed. So I'm going to sue you now. So the reason that's relevant for you is to just be aware, don't expect to go in and get a massive discount. You're not going to buy these properties at half price. We see that all the time. People say, well, it's power of sale, so it's as is, whereas, give me 300,000 off. It's not going to happen. But, the caveat to that is the mortgagee in possession has to get a fair price, not the best price. There's no duty to, hold offers for a certain period of time in order to see if they can squeeze a little more money out of it. They don't have to make improvements to the property to try and get a bit more money out of it. They don't have to wait for the market to improve to sell the property at a better time. They have a duty to get fair market value at the moment that they choose to sell the property. Okay. An important distinction is that unlike a trustee in bankruptcy that has a fiduciary duty to the bankrupt, a mortgagee in possession does not have a fiduciary duty. They have a common law duty of good faith. They have a duty to get fair market value. They do not have a fiduciary duty to do everything they can to maximize value. So there are opportunities for discounts. There are opportunities to buy properties that are distressed at a bit of a discount, but just sort of temper your expectations accordingly. Another big sticking point that we see a lot with sales under power of sale is vacant possession. So, your typical clause in a Form 100 APS is that unless otherwise, laid out in the schedule, vacant possession will be provided on closing. Under a power of sale action, we can evict the owner of the property as well as their, family licensees is sort of the term that's used. So anyone that's an occupant that is not a tenant. However, there are specific protections for residential tenants under the Mortgages Act and the Residential Tenancies, Residential Tenancy Act that applies to those tenants. So we cannot just evict residential tenants because we become the mortgagee in possession. And that can become a real sticking point to get rid of those tenants, unfortunately. But when we take possession of a property, if there are residential tenants that have a valid lease, whether it's month to month, annually, whatever, we cannot disturb their occupation and possession of the property or their occupation of the property. We will step into the shoes of the landlord, and I'll talk about that in a second, but we can't just evict them at that time. Commercial tenants, it's a bit different. It gets complicated, but it basically depends on the priority of the lease versus the mortgage. If there's specific terms in a commercial lease subrogating to any subsequent mortgages. So I can talk about that a bit more, but it's a different story for commercial tenants, but residential tenants are protected. This is a quiet possession. So what this means is that once a mortgagee has possession of the property, they're entitled to maintain possession of the property. The mortgagor, barring redemption of the mortgage, cannot just simply take back possession because they're the legal owner. I've dealt with cases of that in the past where they just show up and, on commercial properties, they show up on a Saturday when no one was there. They take bolt cutters to the locks that the mortgagee in possession has put on the gate. They open it up, they put their own lock on the gate. We have to get an interim injunction. It costs everyone $10,000. It's a disaster. So once the mortgagee has possession of the property, unless the mortgage is redeemed, and I'll talk about what redemption means in a second, you can't, as the owner, just come back in. But like I said, they might try. So that's always fun. So what does it mean when you're buying a property under power sale? The most important thing it means for you is that you are buying the property as is, where is, and the mortgagee is going to make basically no representations or warranties about the property whatsoever. And they're going to specifically either cross things out in the APS or put things in that Schedule B. And so what I'm going to do is go through a number of the standard elements of those Schedule Bs and try and give some sort of information or tips of what you can do as the realtor to protect your client or to just better understand the risks your client is taking on. So overall, the onus is on the buyer to do their proper due diligence. So if you can go in with a due diligence clause or a home inspection condition, anything that gives you that opportunity to really look into the property a bit more, I highly suggest doing so, because otherwise you're just kind of opening yourself up to a lot of liability with no real recourse against the seller, who is the mortgagee. So this is definitely a situation where if you can involve the client's real estate lawyer early on in the process, that's going to really help, because the lawyer can do the title search, they can do zoning searches, they can pull see if there's any bylaw notices or anything like that on title even before you make the offer. I know a lot of clients don't want to involve a lawyer until they have a firm offer. They don't want to spend that money up front for a property that might fall through or an offer that might fall through. But in cases like this, whether it's before you put an offer in or whether you're able to get a 5 or 10 day due diligence clause or condition in there, that is really going to be that's really going to serve you well. And getting that lawyer involved early on to do the proper searches is really going to serve you early on. Because this is sort of a few of the main things that a mortgagee in possession is not going to make any representations or warranties about that a normal seller generally would. So number one, zoning or legal use. I'm the bank. I don't know, if this is zoned as a duplex, a triplex, a single residential. I don't know if this is legal non-conforming. I don't have any interest in finding that out. That's not my job. I don't have the time for that as the mortgagee. So that's going to be, I'm not going to make any representations. I'm not going to say that the current use of this property as a residential single family is the legal use and can be continued. I'm just not going to make that representation. Number two, condition of the property. I can't make any claims about the condition of the property, the workmanship, the age of the roof, the windows, insulation, water damage, asbestos, any of those things, right? A lot of those things that are common to see in an MLS listing, new roof 2022, whatever. I don't know those things. Even if I have documentation, I can't, assure myself that that documentation is valid or up to date. So I'm just not, as the mortgagee in possession, not going to make any of those representations about anything to do with the condition of the property. So again, this is where a home inspection condition is going to come in really handy, and let that home inspector know, look, they're not making any reps or warranties, so you need to do a thorough job. We can't rely on the mortgagee, we can't go after them for anything if we miss anything. So that's, buying a property under power sale without a home inspection is not something I would ever advise you do. Boundaries of the property. Mortgagee in possession is not going to have a survey. We don't know if there's been any disputes in the past about boundaries, any off-title easements or rights of way. I don't know if your neighbor's been using your backyard as his driveway for the last 20 years, because I haven't been there for 20 years. I'm just the bank. Another interesting one is chattels and fixtures. So generally speaking, when a property is purchased, one of the documents that the seller gives to the buyer is a signed bill of sale, which says all the chattels and fixtures that I'm leaving in the property are now the property of you, the buyer. As a mortgagee in possession, I don't know who owns those chattels. I don't know if you've paid for that washing machine in full. I don't know if the brick or Liens still has, financing conditions on that. I don't know if your water heater is rented or owned. And so the mortgagee in possession is not going to warrant or rep ownership of the chattels, nor are they going to give a bill of sale at closing. Practically speaking, it's not generally an issue, because it's very rare for a mortgagor, the owner, to show up one day and say, that's my fridge, give it back. That's generally not going to happen. That being said, it could happen, and the mortgagee in possession cannot make any guarantees or warranties about that. So just, again, something to be aware of when you're talking to your client through this is, especially if there's specific stuff like a hot tub or a sauna that is, arguably removable, not a fixture, if it's an above ground sauna or, a portable sauna, something like that, that may be something that the mortgagee, or the mortgagor, I should say, prior to closing, comes back and says, well, I can't redeem the mortgage, I can't get my house back, but I'm taking my stuff. And they take that. And the mortgagees just can't make any warranties about that. An example, yesterday, we took possession of these two houses that had been abandoned. One of them had 60 boxes of laminate flooring left behind. They were clearly flipping the property, and just, unfortunately, they went bankrupt before they were able to finish that. I don't have ownership of those as the mortgagee in possession. I mean, I'm not the mortgagee in possession, but my client, we can't claim ownership of those supplies. We have the right to the house. We don't have the right to these chattels left behind in the property. So we have to deal with those, but I can't sell the house and say, by the way, these are included. So that's, very important that you're aware that the owner needs to be given an opportunity to collect their personal possessions, bicycles, cars, boats. We see that kind of stuff all the time. And that we're not going to make any reps or warranties as to the ownership of those chattels. Environmental, sort of same issue as as is, whereas generally not an issue for residential properties, but obviously never an issue. So something to be aware of if you're buying a residential property near a dump or a propane factory or a gas station or a car, a car garage, an auto garage. And especially if you're buying rural or commercial properties, agricultural properties, you may want to include a condition that you get a phase 1 environmental at your own cost. Mortgagee in possession is not going to provide a phase 1 environmental, and they're not going to make any representations or warranties as to the environmental condition of the property. As well with rural properties, especially cottages, septic and water potability. We're not going to say that the water in the well is drinkable. We're not going to say that the septic system is sufficient for the size of the property or the number of toilets and showers. So again, something to put in your in the ear of your home inspector. If you can get that information, if you can do a test, put a condition, we want to do water potability testing. I have heard some horror stories about people just dumping bleach down wells the day before the water testing and then it passing because there's nothing alive in it, but that doesn't mean you should drink it. But not something I do, but I've heard stories. So the main takeaway from all of this is, like I said earlier, get the buyer's lawyer involved early on, do proper title searches, zoning searches, bylaw searches, any of those searches that you're going to want to do on a normal property, but maybe go a bit above and beyond, and also do it in advance if you can. See if there's any open construction permits that are going to have to be dealt with, because again, maybe they were flipping the house and there's a permit open and they never got it closed because they took off, they lost, they couldn't afford to work on the property anymore. Is that going to become an issue for your client? Yes. So look and see if you can find out what construction permits are still open and what it's going to take to close them, and then figure out how to account for that in your offer. This is one that I see it in every Schedule B, but I find it odd from a practical standpoint. So insurance. So in paragraph 14 of your Form 100, the seller undertakes to keep the property insured until closing. The challenge with insurance under power of sale is if the insurance lapsed before the mortgagee gets possession, it can sometimes be a challenge to get insurance back on the property. And especially if it's lapsed a couple times due to non-payment, sometimes mortgage or insurance companies are very hesitant to reinsure when the owner is still on title, even if the owner is not in possession anymore. Generally speaking, though, if I had a client and we had taken possession of a property and we found it wasn't insured, we would figure out a way to get that property insured, because if that property burns down while we're in possession, that's a huge problem. Not only do we lose all of our security for our client, but there's a possibility of a claim for negligence and damage from the mortgagor. So while the Schedule B may say, we don't have any insurance, we're not going to guarantee insurance, practically speaking, every good lawyer is going to try and get that property insured. But again, something to be aware of. What I suggest is ask the mortgagee in possession or their agent if the property is insured or how long the insurance is still valid for. If not, get your client's lawyer and the mortgagee's lawyer to figure out a way to get that property insured. Maybe offer to put money down on the insurance during the closing period once the deal's gone firm, but before the deal is closed, because you want to make sure that property is insured, obviously. And lapsed insurance is a very common reason for defaults under mortgages, so we are seeing that kind of stuff. UFFI, everyone's favorite 50s throwback. Paragraph 23 of the Form 100, obviously, seller reps and warranties that there's no UFFI, and to the best of your knowledge has never been urea formaldehyde foam insulation. Mortgagee in possession can't make this rep and warranty, has no knowledge of that. And so we'll specifically say, we cannot make any reps as to UFFI. I personally, from everything I've read about UFFI, it seems like it's probably a bit more of a, and I could be totally wrong on this, but from my understanding of it, it's probably a bit more of a holdover of an old scare of how bad UFFI really is. But regardless, it is in there, and there's a reason for it. And so again, advise your home inspector, hey, can you make sure there's no urea formaldehyde insulation, make sure there's no asbestos when you're going through, because we have no recourse against the buyer if we discover, or against the seller if it's discovered after the fact that there is UFFI here. HST, seller will not collect and remit HST if applicable. Obviously, as you guys know, in a used residential property, there's no HST applicable, but for commercial properties, agricultural properties, industrial properties, there may be HST applicable. And so one thing you want to, if you can, is try and ask the lawyer for the seller in advance if they, if they think HST will be applicable. If they don't give you an answer, ask your own lawyer, hey, do you think HST will be applicable based on the circumstances? Lawyer should be able to give you an answer on that. But again, just being aware that your client, if if HST is applicable, your client is going to be solely responsible for remitting that HST to the CRA. Okay, so let's talk about tenants, because this is always the biggest pain, I would say, when dealing with powers of sale or just buying a property with tenants generally. So in paragraph 2, Form 100, the standard statement is that upon completion, vacant possession of the property shall be given to the buyer unless otherwise provided for in this agreement. Now, a mortgagee in possession is not going to be able to make that declaration if there are residential tenants, if it is a rented out property. If it is a personal property, like I said, we take possession, we evict those owners. And if we get to the point where we're selling the property, they have no right to come back in until they redeem the mortgage. So that in that case, we can provide vacant possession. But if there are tenants, we cannot guarantee that. So something to understand, under Section 47 of the Mortgages Act, a person who becomes the mortgagee in possession of a mortgaged residential complex, which is the subject of a tenancy agreement, or who obtains title to the residential complex by foreclosure or power of sale, shall be deemed to be the landlord under the tenancy agreement. And as I mentioned, Section 5 or Part 5 of the Mortgages Act specifically lays out the protections afforded under the Residential Tenancies Act. I think I referred to it as the Landlord Tenants Act earlier, sorry. And so the tenants are protected under the RTA, and the mortgagee in possession steps into the role of the landlord. So we can start collecting rents, and we can then evict those tenants under the same ways that any landlord could through the landlord tenant board for non-payment of rent if we sell the, or if we sell the property to someone who wants to move in, we can of course start the process of the N12 notice and all that. But it is the same issues as buying any tenanted property. Now, personally, in my own practice, if we are selling, if we take possession of a property with tenants, our first move is to try and get rid of the tenants by cash for keys, because it's going to be so much easier to get rid of those people, or to sell the property, I should say, if there's no tenants in it, obviously. So, we might go in and offer them 3 or 4 months rent in cash in exchange for them saying, yes, we'll be out at the end of the month, signing the necessary forms. We file those forms to the landlord tenant board. If they don't move, we go that process. If that's not possible, and there are certainly cases where that's not possible, the rent was so cheap they can't afford to go anywhere else and they refuse to leave, we would generally advise our client, if you want to sell this property and we can't get rid of the tenants, we will not guarantee vacant possession. And so obviously from a buyer's perspective, you need to be aware of, okay, if we're buying a property and they're not going to guarantee that the tenants are getting out, even if we want to move in, what does that process look like? Understanding that the landlord tenant board is backed up 8 to 12 months right now. How easy is it going to be to get rid of these people for us to move in? And I get this all the time from clients on either side saying, well, but they have to leave. We gave them the notice, or they agreed to leave. And the answer to that, unfortunately, is just because someone said they were going to do something, or just because someone is supposed to do something, the physical reality is they're still living there and we cannot legally just go in and kick them out. So being very, very aware if there are tenant issues, what that's going to realistically look like, what that's going to cost in terms of time and money to get rid of those people, is something you need to talk to your client about and make sure they're very clear on when buying a property. Now, like I mentioned earlier, commercial properties, there's less protections for tenants. The general sort of rule, assuming that the lease was not registered on title prior to the mortgage being registered, or some other sort of specific conditions, the general rule is that the mortgagee can go in, take possession of the property, kick everyone out, and then re-rent it to them as the new landlord under a new lease. And I've seen that quite a bit. It can be a real pain for those tenants because that new landlord, mortgagee in possession, can just jack up the rent if they want. There's all sorts of issues. So that's something that if you are just something to keep in mind if you're acting for commercial tenants, looking at new properties, one of the things to look at in the leases is there a clause subordinating the lease to any future mortgages? Are you allowed to register the lease on title? Things like that. I won't get into that right now, but that is certainly something to be aware of. Couple things one of the things I sort of mentioned earlier is redemption. So during this whole process, obviously, if I'm the owner of the property, I'm trying to generally figure out how can I get my house back? And the main way, or the only way really, is to redeem the mortgage. So redeeming the mortgage means basically paying up, the arrears, the fees, and the principal or bringing the mortgage back into good standing, depending on the mortgagee. Sometimes they'll allow, okay, if you just pay fees and arrears, we'll reinstate the mortgage. Or other mortgagees, depending on the history with the owner, the borrower may say, no, we want out, we want all of our money. So you can pay us the arrears plus the full principal plus the fees and expenses that we've incurred through this process, and then you can have your house back. And so the mortgagor has the right to redeem a defaulted mortgage basically up to the point of closing. So even after your client has a firm offer to purchase, one of the key provisions that's going to be in a Schedule B is the purchaser acknowledges and agrees that the vendor shall have the right to terminate this agreement by notice in writing, delivered to the purchaser or their solicitor at any time prior to closing, if the mortgage has been redeemed or payment is made on account of the mortgage, or if the within sale has been restrained by an injunction or other order or judgment issued by a court. So basically what that means is if that mortgagee in the 11th hour, or mortgagor I should say, in the 11th hour comes up with the 500 grand he owes to the bank and pays them, the mortgagee can say, deal's off, house is theirs again, they've redeemed, and obviously deposits will go back, deal's null and void, but you don't have any recourse. You can't sue for specific performance saying, no, I really wanted that house. You need to be aware that at any time up to closing, they could the deal could be null and void due to redemption by the mortgagor. The other element that they mentioned there is restrained by injunction or other order or judgment of the court. So obviously, a mortgagor there are certain elements or certain actions a mortgagor can bring in the court, either to get an interim injunction to sort of slow the process down, or to have a stay of proceedings based on redeeming the mortgage. It's rare, generally speaking, with residential properties for that to happen, but it is possible if they have cash and they have a good lawyer and their lawyer is aggressive and wants to do everything they can to slow the process down. That could happen. So just to be aware of that. The reason for all this is basically, there's a policy reason that we want to protect people's homes. We want to let people protect their own homes and get back into their homes if they're able to pay for it. So, we want to make sure that people can redeem their mortgages and get their houses back, even up to sort of that quote unquote 11th hour. What does that mean for you? Aim for a shorter closing. Don't have a 3-month closing time. That just gives them more time to redeem, obviously. And I don't say this in a callous way. I just mean for your client, if they really want that property, try and go for a 15 or 30-day closing once you've done all your due diligence, of course. As well, from an agent perspective, talk to the seller's agent, see what information you can get about the mortgagor. Did they abandon this property or were they evicted? Do they own several properties or is this their personal home? Have you heard from them at all? Have they tried to redeem the mortgage? Do you know if they're actively working on refinancing and trying to get this all done? How many other mortgages are on title that they have issues with? And that'll give you at least a better sense of the likelihood of that happening. And so, you can, example, we had a property, it was a farm with a bunch of tenants on it. The owner had just abandoned the property. One of the tenants was his sister, and she was able to tell us, no, he went off to BC. He's not coming back. He won't answer the phone. He's not coming back. So we were pretty confident we weren't going to hear from him, and he wasn't going to try and redeem his mortgage. But in other instances, you might have someone who every week or every day is calling the lawyer saying, what can I do? How do I fix this? And, I'm working on it. I got my lawyer. We got a new mortgage. We're just getting the conditions approved. So, there's always those possibilities for redemption, and it's just something you need to be aware of. Couple more items, and then we'll try and get some question. Property taxes and water can usually represent a lien on the property. So property taxes will be paid out on closing. Other utilities, gas, hydro, generally can't or would not form a lien against the property, so they won't be paid out, but they follow the owner, not the mortgagee. The only difference or the only exception there is actually one property we just took yesterday. We're going to have to set up a utility bill in our name because the power was turned off and we need to get the power restored. So that's something we would pay out from the proceeds. But again, that's not really something the client or the buyer needs to worry about. but property taxes and water arrears will get paid out if they've been registered against the property, or the property taxes are in arrears, they'll be paid out. Notices of security interest. These are everyone's favorite pain in the butt. Every lawyer hates these right now. For those who don't know what they are registered. They're an instrument basically of the PPSA, the Personal Property Security Act, very often registered by people like Reliance and Enercare, but also by people defrauding old people these days, unfortunately, dealing with a few of those. There are very sort of specific rules around whether a notice of security interest takes priority over the mortgage and therefore has to be paid out or is wiped out by the mortgage, the sale under power of sale. The general rule is that if a notice of security interest is registered before the goods become a fixture. So if I register a notice of security interest for a water heater before I install the water heater on the property, that security interest has priority over the claim of any person with an interest in the property. But if I register it after it becomes a fixture, I only have priority over any subsequent interest, so subsequent mortgages. The best way to deal with this, with these, there's two options. Number one, tell the holder of the security to remove the fixture from the property at their cost. Oftentimes they won't. They'll just say, whatever, we're going to abandon it, right? Because a lot of times these things are worth maybe $2,000 and it's going to cost them $1,000 to remove. And they have to do so with the least amount of damage. So a lot of times if you say, you know what, we don't want the water heater, come take it back. They'll sometimes just say, don't worry about it. Or they might come take it and then you just put a new water heater in. Or option two is you can offer to pay the lesser of either the market value of the water heater and its, or the fixture in its condition, or the amount remaining under the contract. Unfortunately, sometimes these contracts, as you guys know, these rental contracts are like 10 times the value of the item. So that's not always the best option. The last sort of subject I want to touch on is just what happens if there's an issue with the actual power sale process? How do I know that this is all valid? A lot of people sort of think that this seems a little outside the norm because it's an extrajudicial process. It kind of seems like, well, you just took the house. You don't have a court order. That's a little odd. And so generally the buyer or the buyer's agent or the buyer's lawyer even is not going to have a ton of documentation about the power sale beyond the declarations made by the lawyer. So Section 99 of the Land Titles Act says the evidence specified by the Director of Titles is conclusive evidence of compliance with Part 3 of the Mortgages Act and where applicable with Part 2 of the Act. And upon registration of a transfer under that subsection is sufficient to give good title to the purchaser. And then Section 35 and 36 sets out the requirements for compliance. Basically, when we do a power of sale transfer, the document that actually says transfer by power of sale, we make certain statements about when we issued the notice of sale, when it expired, the fact that the mortgage is in default, the fact that it has not been redeemed. We're making specific lawyer statements, but that's going to be basically the only evidence you're going to have that this is a valid power sale. You're relying on the seller's lawyer's statements. So what if you find out after the fact that they didn't give proper notice of the sale to the second mortgagee? So the first mortgagee took possession. They don't notify the second mortgagee, hey, we're going to sell this property in 40 days under a power sale. Because when you issue a power sale notice, you have to give notice to everybody with an interest in the property subsequent to you, as well as the owners. So if I didn't send that notice to the second mortgagee, they might be able to challenge that transfer under power of sale. Now, the important thing for your client to know is that absent fraud or actual notice to the buyer that there has been a defect in the power of sale process, a bona fide purchaser for value shall be protected against claims by the mortgagor or subsequent mortgagees that have been wiped off title. And the Act specifically says, but any person damnified there, which is a great word, damnified thereby has a remedy against the person exercising the power of sale. So basically, if you didn't know, if your buyer had no reason to suspect and no knowledge of the fact that there might have been some sort of irregularity in the power of sale process, and you've purchased the property now and you've closed, you're protected, your buyer is protected. But that person who got screwed, be it the second mortgagee, be it the mortgagor saying, you didn't give proper notice, or this wasn't done properly, they can then sue the mortgagee who sold the property. So they still have that remedy, but your client will be protected as a bona fide purchaser for value. So that's just something important to know, that, you don't really have to worry, generally speaking, absent some, huge fraud or irregularities. You don't have to worry about them showing up 6 months later and saying, actually, it's still my house, that sale was invalid, and give it back. Not saying that's never happened, and I'm sure we could go into some cases where that has happened, but generally speaking, the Act protects that, the bona fide purchaser for value. Okay, so that was a lot of information to throw at you. But yeah, the key things to take away are get a lawyer involved early and often if you can. Protect your client by putting any conditions for inspections, financing, due diligence, whatever you can. And just be aware that you're buying this property as is, where is, and so you're going to have very little to no recourse against the mortgagee if you miss something that then becomes a problem for your client.
Matt, do you mind if I take first question?
Sure.
All right, and then we'll just turn our attention to everyone else's because there's quite a few. I just wanted to turn our attention back to HST for a moment. I currently in my office this morning have a client who is dealing with a power of sale, as so many are now, and it says HST is to be in addition to. I explained to my client that, so you mentioned helpfully, go speak to the lawyer. So they spoke to me as the lawyer and they said, all right, is HST applicable? I said, well, here's the law surrounding HST. HST, if it wouldn't be payable by the seller, is not payable in this instance. But we have no way of determining whether or not it's payable by the seller. So the best that we can do is determine that this is true residential surplus, meaning that it's exempt from HST payable. She said, well, what assurance do I have that there's been no input tax credits levied? That's the definition of what would actually then make it HSTable. I said, I can't give it to you, and I don't know of any way that we can actually verify that other than just doing our basic research and figuring out that this is truly a residential property. Do you have any tips for people here as to how we can give assurance to our buyers that HST will not be paid because it has been used purely for residential purpose?
Right. Yeah. And that is one of the tricky ones. And of course, that is the reason for that sort of Schedule B provision, is to say, we don't know. The best thing, the best advice I can give is that the agent that is selling this property is going to have, ideally, is going to have been involved relatively early in the process, more so than, maybe a typical sale. They're going to have been involved from when the lawyer took possession, and will have access to a decent amount of information from the lawyer, rather than having just to rely on, their own client. Because as I'm sure we all know, sometimes our clients don't have all the information that they should have about their own properties and lives. So, taking the time to really talk to that agent, or ask to talk to the lawyer for the seller, and see if you can just get on the phone with them for 10 minutes and get as much information that they're going to know, because generally speaking, they're going to have a decent understanding of the history of the property, or at least the history of the borrower, I should say, because their client lent the money. Their client should have done their due diligence at the beginning, lending the money, to find out, okay, well, what are you using this house for? Is this going to be a flip? Is this going to be a rental? Has it been a rental? Are you a numbered corporation? Those sorts of things. So if you can get any sort of that information, that's going to help you make that sort of best determination. But unfortunately, there is no guaranteed information, and the mortgagee in possession is never going to guarantee the validity of any of that information, specifically to cover their own butts. And I just hate HST issues, generally speaking. I just find them such a pain.
Fair enough. All right. Maybe you can turn your attention to the chat, and maybe what we do today, instead of just reading the questions, I'm just going to call on people. I'm going to ask you to take off your video if you can, just so we can see your smiling mug as you actually ask Matt a question to make it a bit more engaging. So Hannah, you had a question. Why don't we start with you? Feel free. The floor is yours.
Hi. Yeah, I had a question about the owner getting back in to collect their possessions. I'm a little confused as to what the timeline is, whether that's set in stone or they can come at any point in time.
Right. So generally speaking, what will happen is if we have contact information for the owner, if we've specifically evicted them, or we know where they're living, or we have a way of getting in touch with them, we will advise them if there is stuff that they've left behind. We will advise them property is getting listed for sale or is up for sale. And we'll give them a deadline. We'll give them 10 or 15 days to pick up their stuff, failing which we will then put it into storage, and we will have to pay for that storage, and the cost of that storage will be added to the amounts owing under the mortgage. And once the property is sold, you will get the contract for that storage and you'll be responsible for paying for it. Otherwise, I don't know what that storage guy is going to do with your stuff. That's your problem. That's generally the way we have to handle it, is to say, look, you got to come pick it up. Otherwise it's going into storage. And once we've sold the property and we're not paying for that storage locker anymore, that's your problem. Usually when it comes to those kind of items, if the person is in touch with us, we'll work with that person. We don't our job is not to I don't know. I realized when I was watching a Christmas movie the other day that Scrooge is a lender and also evicts people, and that didn't make me feel great. But our job as lawyers for mortgagees is to work with the borrowers to get this problem resolved. The less time we have to spend on it, the less work we have to do, the more money that we're saving for the mortgagor in the equity of their home. So if we can work with them to say, look, come tomorrow with a moving truck and we will be there and we'll unlock the doors and we'll give you all day to get your stuff out, then we'll do that. But if we absolutely can't find the person and we need to get the stuff out because we need to stage the house or we just need to clean the property out, we're going to give them 10, maybe 15 days notice, failing which we'll put it in storage.
Okay, thank you.
Linda Wallace, up to you.
Good morning. I had a question regarding representing the buyer's side, and you were talking about the 11th hour redemption. So from a buyer's position, what would their liabilities or obligations be if they've got all their mortgage documents lined up and, maybe even the check has been cut, if you will, sitting at the lawyer's office ready to go, and at the 11th hour, they don't get the house? So what position does that put them in with mortgage commitments, et cetera? Are they now in a bad spot?
Right. That's a good question. I'll be honest. It's something I have not dealt with before. So it's something I'll look into a bit more detail. But, what I would say to the buyer and to their mortgage broker is to make sure the broker is very aware that this is a power of sale purchase. And they should be aware of that if they see the APS. But make sure that their mortgage broker and their mortgage lender has been made aware this is a power of sale purchase. So there is a possibility of a redemption and this falling through, and to structure the mortgage deal in such a way that sort of acknowledges that, because generally, realistically speaking, what's going to happen is if there's a redemption, that APS is deemed null and void and the contract, dissolves. So you don't have the right to buy that house anymore. So how can you put a mortgage on that house? I don't know in terms of, if there's going to be fees from the broker or fees from the lender for the work they've done to that point. But I would say that the most important thing is make sure your broker is aware and ask those questions. Say, look, if this does fall apart, am I going to get charged $2-3 grand by the bank? And sort of cover yourself that way.
Great. Okay, Wesley's asking a question. I'm just going to take this one. Wes, has anyone challenged a nosy contract on the basis that it's usury? That doesn't really have much to do with power of sale, but if it's over 60%, yes. And just FYI, contact Greg Whedon. He and I are working on that very case at the present time. So we'll know the law on that one if you're working on a case for that. Someone asked me privately, is the recording going to be placed? Yes, it will be on our site. It will be up within about 2 hours. It always is. So just hang tight. And of course, our YouTube channel will have a copy of this recording. Amin, why don't you go ahead and ask your question? Amin, are you there? Oh, no. Okay. Your camera and audio are giving you problems. So Amin asks, what if the mortgagor in default is a non-resident? Is there any way to find this out? Would a 25% or 50% holdback still be applicable since it's a POS transaction? So does Section 116 apply to POS positions?
That is an excellent question that I've not encountered, and I'm going to look into that and get back to you on it.
Okay, awesome. Okay, Maybelline, go ahead.
Hi, good morning. So I'm rather new in real estate law, and I was just wondering, with the sort of laundry list of recommended searches that you sort of outlined, which was very helpful. I'm wondering whether title insurance has any role in a power of sale and can protect the buyer for any sort of searches that hadn't been done, or any due diligence stuff that hadn't been.
Right. So, I mean, I think the blanket answer is title insurance certainly does have a role, and it's one of the reasons we recommend title insurance on all purchases. As between, the buyer's lawyer and the title insurance company, the buyer's lawyer has a liability or responsibility to the title insurance company to make their report on title, to do the necessary searches, and then advise title insurance accordingly. So in terms of those searches, it's going to be something that the buyer's lawyer could specifically request that the title insurer insure over if there is an issue that's unknown or unknowable at the time. That may raise the cost of your title insurance policy, but it is certainly something that can be, customizable to an extent by the title insurance company to cover off those sort of unknowns or unknowable issues, and is certainly something that I think a buyer's lawyer is, if there are any buyer's lawyers out there that don't get title insurance for residential transactions purchases, this is certainly the time when they want to be, and making sure that they're communicating clearly with their title insurer about what they do and do not know, or can and cannot know, and seeing what can be insured over.
Thank you.
Great. Okay. Now we have time for 2 more questions. So, Ron, go for it.
Great session, guys. My question was about condos. What if the power sale is a condo? What about status certificates and any special assessments?
Yeah, so the status certificate is provided by the condo corporation, not by the mortgagee in possession. So if the mortgagee in possession won't provide it, doesn't have one, your lawyer, the buyer's lawyer, can always order one. There's a number of services that you just order those through, and they can get that. But again, the mortgagee in possession, if it's a condo, is not going to make any warranties that there haven't been any special assessments. So in that case, it's very important for you to order that status certificate and check those things to see that those declarations made by the condo corporation are all there.
All right.
Awesome. Thank you.
Guys, we have time for 1 more. Anyone who wants to throw one out, first person to ask, you're welcome. If not, I'm going to wrap up.
Okay, I want to say something here, please, Neil.
Yep.
Hello?
Go ahead.
Okay.
Neil.
Yeah. I just want to know, the mortgagee seems to know nothing about the property, and he's lending 90% value to this property. And according to Matthew there, he doesn't know anything about it. Number 1. Number 2, sorry. You got every time an insurance change, a borrower we insure the property with any other, the mortgagee is always being informed. Isn't that correct?
So on your insurance, it should show when you have a mortgage, it should show your mortgagee as lost payee, right? And very often, what will happen when properties go into distress is at some point in the process, the mortgagee will receive a letter from cooperators or whoever saying, by the way, this insurance is going to be canceled in 10 days or 15 days due to lack of payment by the owner. My advice to clients at that time is always to call the insurance company right away and offer to pay and reinstate that insurance and get it covered. But there are always instances where we don't get the letter in time, or they send the letter after the insurance has already been canceled, or the letter arrives after the insurance has already been canceled. And we've run into issues where the insurance company will not reinstate the insurance until we have possession of the property. And even then it can take some time. So it's really just from a practical standpoint, it can just be a pain to deal with those insurance companies. And but from a practice perspective, I always try to ensure that there is insurance, because we don't want that house to burn down.
Also, the title search that should be made early, I believe, on the offer.
Yeah. So if you can have a title search done prior to your offer, or have a condition for a title search, but a a good lawyer can pull title and at least look quickly at the title insurance relatively easily at the title search relatively and easily and fairly quickly to at least say, okay, there's some huge red flags here, and advise you if there are those massive red flags. But yeah, if you can build in a condition that gives you, 5 days due diligence, and then just contact the lawyer and say, hey, look, I know it's not firm yet, but I really need you to do these searches, and I'll pay for those if this deal falls through, because I just need to know before we lock in what possible issues we're going to be running into.
So when mortgagees giving mortgages, they don't do no search in these properties to know the detail about them?
No, they do. I mean, when I act for lenders, we always do a title search. We see, because we need to know if there's anyone ahead of us, if there's any notices of security interest, all these other things. But that might have been done 3, 4, 5, 6 years ago, and now the mortgage is in default. And again, when I start my power sale action, I'm pulling title right away. I'm looking because I need to know who else to give notice to. I need to know the history of the property, all these things. But as a mortgagee in possession, when I'm selling the property, I'm not going to make any of those warranties to you. That's not my job. I'm not going to say, oh yeah, we've looked at title, it's all good. I'm just not going to open that liability up for myself as a mortgagee in possession, and I'm not going to do it for my client, obviously.
Well, originally you should know if there's any existing easements and stuff like that.
Yeah, if they're registered on title, but there may be off-title easements, off-title instruments, or off-title issues that are just not going to come up. And again, even if I'm aware of them, I'm not making any reps or warranties to you, the buyer, because I'm just not opening myself up to that liability.
Thank you.
All right, guys. So I'm going to call this to a head. Guys, there is a reason that you go to people who specialize in areas of law that they have spent years honing their craft in. And you can see that today in what Matthew does. You guys will be dealing with more and more power of sales. When you do, please approach legal counsel who are not just your friends, but ultimately have deep knowledge in their subject areas. As you can see, there's a quantifiable difference between a lawyer who engages in power of sales every day and knows this inside and out, and those that do not. Please, please, please keep Matthew in mind, both for his service to the group, but also for his service to your clients, because he is one of those people who really knows the ins and outs of the subject, which is something we will all need as we kind of march on into 2023 and the surprises that await us. Matthew, on behalf of the group, incredibly grateful for your time, for your expertise. We invite you back. I know you've been a constant contributor, and we're looking forward to having you continue in that vein over the coming months and years. And perhaps in 2023, we'll see your smiling mug back here, commenting on maybe trends or what you're seeing in the power of sale market, which will undoubtedly continue to increase in the near term. Guys, thank you everyone for attending. This will be posted within 2 hours to the website and on our YouTube channel where all of our videos are hosted. Take care. Have a good day.
Thank you, Matthew.
Thanks, everyone.